So I wanted to go over the three most common mistakes that I see as an immigration lawyer for people who have filed I-130 petitions. So the I-130 petition is filed to fix spouses as well as children and parents. So the number one most common mistake that I see on the I-130 is there is a portion of the I-130 that asks whether or not the immigrant will be adjusting their status in the U.S. or if they will be obtaining an immigrant visa abroad. So one common mistake I see is sometimes people will state that somebody is adjusting their status in the US when in fact their relative is abroad. Now this mistake is very serious because although they will approve the I-130 petition, what happens is it ends up costing the person more time, sometimes another year and a half. And that's because you have to file a special form now because of that mistake to now notify immigration that the person will be consular processing or fixing their status abroad. So that would be the number one most common mistake. The number two most common mistake that I see is when somebody is filing for their spouse, they not only have to file an I-130, they have to file an additional form. It's called an I-130A. And I have seen people who have admitted that and not submitted it, and immigration ended up denying the I-130 on that basis. The third most common reason is not having documents translated from a foreign language, or alternatively, even if they are translated, the translation not being a certified translation. And so those are the three most common reasons I see an I-130 either denied or an I-130 kind of having issues because of mistakes.